My name is Chuck Dick. I have the privilege of being one of the co-chairs of the programming committee for California Arbitration, CalArb, and one of my privileges really is to serve as a host of this series we call California Conversations. And today we are really privileged to have with us one of the foremost figures in international commercial arbitration in California and the western part of the United States, I dare say, Peter Neumann. Peter has really got a very distinguished resume, and I'm eager to spend some time having it unfold for you today so you might get to know him a little bit better and to understand a little bit about the trajectory that has brought him to where he is today, in case that you might very well want to follow in his footsteps. He'd certainly be somebody worth emulating, and I'm very happy to have you with us today, Peter. Welcome to California Conversations.
Well, Chuck, thanks so much. I really appreciate your very gracious comments. I'm ready to hire you as my personal publicist. My claim to fame that I am the second most prominent fluent Mandarin speaking international arbitrator in California after the illustrious Sally Harpole. But I really appreciate your very gracious comments, and I'm just very grateful to be part of this community and really appreciate all the service that you've performed for building community here in California.
Well, you and Sally are good examples of how California practitioners have bridged the ocean between us and Asia. And we're going to spend some time today plumbing that a bit. But first of all, I'm dying to know how in the world you got to California in the first place. Your undergraduate education on the East Coast. Are you a California native?
I am not, but the family moved here when I was 6 years old. My father had two attractive job offers. One was from the University of North Carolina. The other one was UCLA, and we wound up at UCLA. And my parents spent most of their careers as professors of international health at the UCLA School of Public Health. And so I'm a product of California public schools, and then decided to broaden my horizons by heading back east undergrad, and then came back to UCLA for law school, and then began my career here in Los Angeles.
Well, you've just given us a hint that might very well explain how you began to develop such a keen interest in all things international, including foreign language studies at Dartmouth. So, how did you end up going to Dartmouth? And tell us a little bit about how that educational experience at the late adolescent, early adulthood age began to be so formative.
Well, I had the good fortune back in the 1970s of reaching a threshold on the SAT. My score was sufficiently high that I qualified for an honors program that permitted me to take a college class during my senior year of high school over at UCLA. And really, just on a whim, it was almost a joke. My dad suggested with a chuckle that I study Chinese. So I took first year Chinese when I was a senior in high school over at UCLA. Wound up at Dartmouth fully intending to be a biology and pre-med major, but I got hooked on Chinese. I got the bug and did an intensive summer at Middlebury's highly regarded program, and then did a junior year abroad and never looked back. But then I needed a profession, and that's where law came along.
And your degree work at Dartmouth was in Asian studies.
It was actually more specifically Chinese language and literature. And it was something that was very engaging, but also very challenging, as I elected to write a graduating thesis, an honors thesis, entirely in Chinese back before they had China. Laid the foundation for being.
Well, it may also say something about your willingness to undertake seemingly insurmountable challenges. Just the thought of that leaves me sort of breathtaking.
Well, it's something that just takes a lot of focus, but I'd say the difference between Chinese and most languages is that Chinese does not have an alphabet. It's the characters are ideographs. You just have to memorize several thousand to be able to really function well. But it's something where you get immersed in the culture, you get immersed in the history. What's fascinating is how one can trace the origins of a very abstract Chinese character back 5,000 years to when it was originally more or less a hieroglyphic. And that sort of depth and very direct connection to history and language is something that I found very enriching and attractive.
Well, with your family background in the academy and your really very intense academic work at Dartmouth, one could have foreseen you going into a variety of vocations, perhaps teaching being one, but not the law. So tell me about that decision.
Well, I had originally, the way that came about, when I graduated, I had verbally accepted a job offer to help a company that was a vendor to a company that was owned and operated by a friend of the family. That was supposed to be on the ground in China. That fell through. And so here I was, had just graduated from college and was left holding the bag, so to speak. Explored various things, met with various experts in various fields, and I was introduced to a Professor William Alford, who was a China law scholar at the time at UCLA. Headhunted over to Harvard, where he ran the Chinese legal studies program. And what he presented to me was an interesting opportunity to be able to put my language and literature background fully to use professionally through the practice of law. And that was really my impetus to apply to law school. And it's really been a very interesting ride because, in fact, I have been able to fully utilize my undergraduate background in my profession.
We did come back to UCLA for law school, and that maybe explains a little bit how you entered the profession here in Southern California. But I'd be interested in having you share that part of your biography with us as well.
Well, the transition into law practice, well first of all, I had three options when I applied to law school, when I decided to pursue the study of law at UCLA. You remember one of those game shows where you have to choose from three different doors? Well, door number one was to be a payroll clerk on a B movie set in China, wage to hand out pay packets to the crew. Option number two was to be an unpaid intern on a basically a sturgeon farm up on the Amur River, up on the Siberian border with China. It was they wanted to develop a commercial caviar operation. Perhaps I should have done that and gotten paid in frozen caviar. I might be fully retired now if I had done that. And then option number three was law school at UCLA back when there was, in effect, no tuition for in state California residents. We had to pay $1,500 in fees a year. But I basically got a wonderful education courtesy of the California taxpayer. And I did choose door number three. And it's been a wonderful ride ever since. Part of law school did involve going back to taking a leave of absence with some classmates to go back to Beijing again. And during that time, in addition to more advanced, attend Chinese law school where I studied Chinese law in Chinese for a semester. And again, that was a part of laying the foundation for professional use of Chinese later on.
Well, you did begin your career as an attorney here in Southern California with the Bryan Cave and their office in the west side of LA. And that ultimately, though, led its way to you moving to China. And that's a fascinating part of your biography. I'd love to have you share.
Certainly. Well, I did make a decision early on that it was important to really get a good foundation in US legal practice. And my long term goal was to move back to China. And I felt that the best way to do that was through a transactional practice. So I started my career in Bryan Cave's LA corporate department, really just doing very traditional corporate work, a couple of rotations in litigation, which frankly I found a lot of fun. And maybe I missed out on some interesting disputes work along the way, but it was really just basic grounding, corporate M&A. Worked on did lots of secured lending documents. Also worked on a couple IPOs. Just a basic, fairly broad-based corporate practice. But then what really pushed me to go back out is in the early 90s, there was a very sharp recession. And almost overnight, the deal work just dried up in Southern California. And so, if I wanted to stay with Bryan Cave, I would have needed to either pivot to becoming a litigator or becoming an immigration lawyer, neither of which I was particularly interested in. So, I headed back out to China, worked initially with some friends that were doing an electronics manufacturing startup, but then I had an of counsel position in the law firm, in a law firm started by a Chinese law school classmate. And then we worked on some interesting things. Some the first Gulf War reparations petitions. We were working on some of those, and then had a corporate client that was a for a year out in Sichuan, just down in Hong Kong.
Well, the combination of your experiences in the private practice in China, as well as serving in-house as a client, in effect, would be, I think, a telling part of the shaping that who you are today. And explain to us a little bit more that as you look back on it, the things that you really learned and pulled together in your skill sets with a combination of those two practices.
Well, a couple of things. First of all, it's important to be, well, I think good technical learning skills are very important. And I feel I got those from my first few years at Brian Cave. And, habits of being very precise and mindful when one's drafting, for example, if you don't learn that early in your career, it's difficult to develop later. But what I would say in China is what's interesting is understanding cultural differences and then understanding how much weight to give to them. One thing that I found very interesting early on is that we primarily represented in my law practice days with international firms, we represented probably about 70% US companies, and the rest were a mixture of Japanese and European. In more recent years, represented Chinese companies coming out of China. But back then, it was interesting how Chinese counterparties, when they wanted some flexibility in the deal, they would say, "Oh yes, in China, this is our culture. We trust each other. We keep our contracts simple." It's if we implicitly that if we were insisting on very rigorous contractual protections, that somehow called into question whether or not we trusted them. On the other hand, when Chinese parties decided that it was in their interest to have very tightly drafted contracts with lots of useful remedies and conditions and so forth, they could hold their best with whoever you might find on Wall Street. So it was interesting. They're very practical in that regard. And one of my observations has been that it's important to really understand what are the business fundamentals behind a transaction, especially when a client is new to China. Does it even make sense? And I would sort of draw my own conclusions if I felt a deal was sensible for the client, if there weren't any very glaring red flags commercially or legally, then I would try to become an advocate for the deal and really help them do the needful to actually get it done.
The the experience that you just shared with us about the culture, if we could go peel that onion back a little bit further, that is something that I think all of us could benefit by understanding a bit better how the cultural makeup, the traditions, and the well-established practices and the local scene may very well be misunderstood by those of us in, for example, in the West. Tell us a little bit more about some of your experiences in that regard and how your growing into this cultural experience in China was of great benefit.
A couple of things. First of all, it's very important to recognize that China, it's an ancient culture, and the role that relationships play are very important, and they should never be neglected. Now, of course, there's a reason why Chinese parties increasingly do like to have well-drafted, tight contracts, especially in complex transactions. It's very interesting to see that aspect of legal culture just grow before my eyes over the years. What I would say though is in the U.S. we do have a very it's probably more it's a bit of a caricature, but you think of Wall Street, you have a lot of tough negotiating, a very bare knuckles sort of environment where parties can be pretty abusive of each other just to get a deal hammered out, and nobody takes it personally. It's just part of the culture. In China, though, it still is very much respect and acknowledge the interests of the other party. And that doesn't mean compromising any of the legal requirements of the deal, but it is existing in that context. Now, there was a time in China when there was probably an overgeneralization that a contract doesn't mean much. It's really just the starting point of a new negotiation. I think that Chinese commercial culture has evolved a fair amount since then, but there is a lot of variability. And I think legal protections overall are getting better. Courts are getting more sophisticated. But it still is important to really think in terms with any deal, more so if there's a state-owned company on the other side. But it's important to really think of the web of stakeholders that are involved with anything, who is going to be weighing in on the deal, who is affected, who is going to somehow be determining the outcome. If it's a purely private party, then the owners of the owners, founders, executives, they can probably make most of the decisions. But even in their case, they probably have a somewhat nuanced relationship with local government. And that does require, I think, the extra work to almost do some relationship mapping in a commercial sense, really understanding who are the different players, what's in it for them, if understanding where the sticking points really are on the other side. It's important, if there's anything that might stress the relationship, it's important to really think through what's being gained from it. I mean, there have been some negotiations that were pretty tough, frankly, where we would start taking umbrage to and declare the other party's position stonewalling and storm out now and then. But that was done very tactfully, with quite a bit of tactically, rather, with some thought as to why we were doing it. But generally, it's important to recognize that it is a different cultural context. That being said, it's important to never lose sight of what the real fundamentals are. And probably, again, I think a bit of a truism, but I would tell clients that, a good contract can never fix a bad deal. If there is some fundamental unresolved tension, commercial tension, relationship tension, just because you managed to conclude a contract that you as a foreign party were satisfied with, that doesn't mean that your problems are over. It could just be the start of a difficult relationship. So it's very important to get to the fundamentals early.
Peter, it's perhaps understandable that we sit here in California and we generalize about China. China is a very big place. And I wonder to what extent do we become short-sighted when we speak generally about China as if everybody does things the same way?
No, absolutely. I think it's important to recognize that it is nuanced, it is complex, and you understand where there are some cultural differences. It's important to appreciate the role of the government, and you're probably more so now compared to 20 years ago. There isn't, in terms of policy and orientation, the government is very much in line with the Communist Party. There was a time when they would talk about the separation of party and government, but in functional purposes, there's not much separation now. It's I would say, though, it's something. It's important, I think, to never view China as being static. It's important to recognize that it is diverse in the sense that there is a lot of diverse talent in a lot of different parts of China. Very interesting article in The Economist about how Chinese brands are starting to get a lot of traction internationally. And that really grew out of Chinese consumers viewing Chinese brands as being more interesting and better value than some foreign brands. But now China was viewed as the low-cost manufacturer. Now they're getting very good at branding. And again, what does that mean? That means specific entrepreneurs. I think it's important to avoid this idea that China is some kind of monolithic block, and every Chinese individual is somehow an extension or an agent of that. And I would never underestimate the talent pool there and its ability to innovate.
You have come back to California. You have established a practice here in Southern California. Tell us a little bit about your thought processes, the timing of this, and explain a bit for our viewers what's going on in your professional life right now.
Certainly, I'd be happy to. My pivot from corporate law to international arbitration, it did have an interesting sort of evolution and also some inspiration from role models. And I'd say probably my leading role model is Sally Harpole, who was actually my direct boss for about 5 years back in my China corporate days, and observing how effective she was in making that transition from being a China-oriented international corporate lawyer to a very prominent arbitrator. And it's not an easy path. But what I found were family reasons. Initially, most of the practice traction was outbound investments by Chinese companies. But then back around 2016, 2017, the Chinese government got very nervous about massive hemorrhaging of their foreign exchange reserves. I think at one point in the space of about 6 months, their foreign exchange reserves declined by about $900 billion. And then There can be some policy overshoot there, so they made it very difficult for foreign currency to leave China. And so all of a sudden, clients were having their deals canceled. Even at that point, I had opened and was running the LA office of a prominent Chinese law firm. And even my partnership distributions couldn't come out. And one of my partners actually had to very kindly send me my draw from his personal US dollar bank account in Hong Kong. And I just decided this is really, I just didn't want to be at these cross-border policies, investment policies, foreign exchange control policies. I was headhunted over to a private equity firm, the private equity division of Ares Management, to do some work on their China funds, which then gave me a nice window into the whole PE world and late stage VC world in China. But then I started doing some soul searching. What is a professional direction that could allow me to fully utilize my background, but allow me to grow and develop for the next 20 years or so? My mother didn't retire till she was in her 80s. And I didn't want to be in a law firm or corporate legal department where after a while you age out. And as I learned more about international arbitration, I became more and more fascinated. So I wound up taking a semi-sabbatical, still had some of my own personal clients. And as part of this transition, I completed an LLM in international commercial arbitration at the Strauss Institute for Dispute Resolution at Pepperdine. Worked very closely with Jack Coe, who was my mentor and now colleague as I teach over there as an adjunct. And that was just a really great way to get a grounding in international and understand the differences from domestic dispute resolution. And COVID came along, which probably delayed my pivot a bit, but really started from the ground up as an arbitrator. The initial arbitrations were pro bono arbitrations for the LA County Bar, mandatory fee dispute arbitration program. And then that gave me some experience with pro se claimants, and the AAA was looking for arbitrators that had that sort of experience, which then put me in a position to join the AAA panel. And Dana Welch, who's very well known in California, was quite supportive of that process, made some introductions. And then after some initial commercial arbitrations, or rather consumer arbitrations, started taking on more commercial arbitrations. More recently joined the FINRA panel and also the ICDR panel. And also through some Chinese arbitration institutional panels that I've joined, I've now getting more traction with Chinese arbitrations where it could be a combination of Chinese parties, Chinese shareholders of offshore companies with disputes. I recently received an appointment as the chair of a tribunal in a CTAC arbitration seated in Beijing that involves an oil purchase contract, a crude oil purchase contract dispute between a Chinese-owned African entity and a mainland Chinese entity. And it's actually very exciting to be able to actually study this academically and now be putting it. That's just really my direction, to continue to focus on corporate disputes, shareholder disputes, post-M&A disputes, and that really have some kind of China connection. I've also, it's really been sort of opportunistic, but I've discovered that I've actually had a fair amount of experience with tech disputes involving computer software development contracts, and privacy issues and so forth. But so far, so good. Again, it's a lot of work, but it's very rewarding work.
Sitting now in a position as a neutral, as an arbitrator versus being an advocate, I'm interested in whether you've been able to make any observations about differences between commercial arbitration in China and what we customarily think of it as here in the United States.
Well, I would say they are inclined to rely more on documentary evidence as opposed to live witness testimony. One thing that it's probably more anecdotal. I can't really give you individual cases to treat it as a statistic, but I found that generally the Chinese parties, they seem to be quite deferential to the tribunal. I haven't seen them getting as testy as some U.S. counsel might be. I found some U.S. arbitrations where it's counsel that are probably more accustomed to domestic court litigation, that they will probably be in the course of how they approach the whole procedure. They are probably leaning much more toward the zealous advocate posturing, and at times that can create some tension. So I'm finding, an important skill as an arbitrator is to just be obviously focusing above all else on procedural fairness, but also being able to be somewhat firm in proceedings in a way that does keep them moving forward and try to achieve some efficiency in the process.
Peter, one of the things that you have done and very successfully is to pursue a course through the Chartered Institute of Arbitrators, and you've become active in the Chartered Institute. Tell us a little bit about your thought processes there and the benefit that you see in your participation in an organization like the Chartered Institute.
Oh, no, absolutely. It's my first contact with the Chartered Institute. It came out of a conversation with John Garman, who's historically been quite a prominent arbitrator in California and very active with the Chartered, and accelerated route to fellowship program, where it's for practitioners that have been at the time who had been out working as practicing lawyers for at least 10 years. And it was really a wonderful crash course, trial by fire in international arbitral procedure, working with some very highly experienced traders who were the faculty. A lot of rapid fire management of procedural issues, and we were using the answer trial rules. And then there was the capstone of that long weekend program, where having previously drafted the sort of the boilerplate, so to speak, of an arbitral award, they would give us the remaining facts, and then we had 4 hours to complete our award, and then it was graded by an international panel. And not everybody passes; it's not a trivial exercise by any means. I have found that the Chartered Institute is just a wonderful way to connect with other practitioners across the US and, very importantly, in Asia. The organization is very strong in East Asia, and it's just been a wonderful way to have an instant network in Greater China. My first post-COVID trip back to Hong Kong, I just looked up on the website the current and past chairs of the Chartered Institute East Asia branch, which is based in Hong Kong. And just on the basis of cold emails to them, they agreed to meet with me and made more introductions. And then every time I visit Hong Kong, I join their annual meeting, their other activities. And it's just been a wonderful source of connection to the international arbitration community. And chairing the Los Angeles local chapter, I really need to do more with that. LA can be a bit challenging getting people together. But also, I participated in a thought leadership working group that recently developed a set of guidelines for use of AI in international arbitration. And that was a very gratifying experience. It was really an honor to work with some very talented individuals from multiple, well, they all had a legal background, but then they came to law from different disciplines, both from Europe, from the US, as well as from Africa. And that's just been really very validating to see how well received those guidelines have been.
I've heard it said that you can't have too many friends, and your description of just sending an email message to somebody in Hong Kong and saying, "Could we get together for a cup of coffee or more?" is a perfect example of how anybody moving into this field could learn how to make some new contacts, how to establish professional relationships. And another example that you have pursued very effectively is the Institute for Transnational Arbitration. And I tell us a little bit about your decision to become involved with that organization.
Well, that was very recent. Professor Cove, several years ago, he recommended that as their annual meeting and workshop as an important event to attend. For various reasons, travel, family matters, I didn't get around to it until this year. I attended my first ITA meeting and workshop in Houston the week before last. It will now be a regular fixture in my calendar, a very high quality program and a strong sense of community. And people literally came from all over the world to attend, and it's a very high quality organization. And I think in its own right, pursuing thought leadership in international arbitration, as well as very effectively building community.
Well, I'd like to shift gears a little bit and have you share with us another facet of your personality, and I dare say even character. Peter, your work with the Mona Foundation has been really significant, not only in terms of the work that has been done, but as well as the impact it's had on you. And tell us a little bit about that.
Well, the Mona Foundation, you'll hear at the end of the day, whether we're neutrals or practicing attorneys, it's a It's remunerative. We're working with businesses that are pursuing their own bottom lines. And, I've always felt that there is a need to do something which is going to be, beyond this abstraction of doing something for the greater good, doing something which is really going to help develop human capital in parts of the world that are very much neglected. And I was introduced to the Mona Foundation through an old friend who was a board member, and she recruited me for the advisory board. And then I joined the full board a few years after that. So it's been out for going on 10 years. And it was founded by a woman named Manas Javid, who was very successful in her own right. She was a C-suite executive with a large Microsoft subsidiary. So she did very well for herself in the US corporate world. Now, her story is this. She was a member of the highly persecuted Baha'i religious minority in Iran, and she was a refugee around the time of the Islamic Revolution. One of the core teachings of the Baha'i faith is universal education and the equality of men and women. And there's also an interesting teaching that families have an obligation to educate their children, but if they're of limited means and they have boys and girls and they can't afford to educate them all, then the girls take priority. And the reason is that the girls, many of them tend to go on to be mothers, and the mothers are the primary educators of their children. And so here, I think in some ways, this is her constructive response to the oppression of women in Iran and the persecution of herself as a Baha'i, to start a foundation whose primary mission is to promote women and girls' education in parts of the world that are very much under-resourced, and in some cases, societies where women have had very low status, for example, various parts of India. And what was a real eye-opener is by carefully selecting local schools and NGOs to partner with, Mona Foundation is the funding agency, money can be put to an incredibly efficient and transformative use. There's one organization that we support in India that runs one-room schoolhouses in slums in India. For 11 US dollars a day, basically think of 1 or 2 trips to Starbucks, you can keep a child, you can see them through $11 a month, you can see a child through their primary education. And that is the difference between basically living on the streets and having a career, starting a family, and living a very meaningful life in India. Now, that's probably the most prominent example of efficient use of funds. Other places have more overheads, but it was just a real eye-opener about how, when an organization really understands the needs on the ground, is very much integrated and part of their community, they can really bring about very meaningful change. And it's been an important part of my life in terms of pro bono and extracurricular activities.
Well, Peter, we are fortunate to have a person of your value system among us here in California and helping to build us for the decades ahead. I would love to wrap up by asking you to share some views that you might have about the future of arbitration here in California and where you see not only your practice, but the profession perhaps writ large moving forward in the days ahead.
Certainly. Well, I think in California, it is important that we continue to promote the message that, despite what we read in the press and some larger trends that we see unfolding, is that, first of all, the judiciary in California, and we're, as international practitioners, we're mainly looking at the federal judiciary. They don't hold grudges. They are unbiased. They'll treat they'll treat a Chinese company, an English, a Chinese party, an English party, a French party, a Brazilian party. They really are focusing on the law. And I think it's important to bear in mind that they are very fair, they are sophisticated, and very supportive of international arbitration. And also the depth of our talent pool here. Pretty much any language one can think of has native speakers and probably at least a few lawyers who are fluent in that language as well. Since the California changed its laws to, in effect, permit international arbitrations in California without any formalities, that's a very important development. And already, I don't have statistics. Perhaps the ICDR has some statistics of their own docket. But right now, I'm involved with three different arbitrations, either as arbitrator or counsel, where there are that are all seated in California, and they involve either Chinese entities or Chinese owned entities. And for various reasons that all reflect the strengths and legacy of Chinese economies, of California's economy, they decided to pick California as a seat. One is in the entertainment industry. Two of them involve governance and shareholder disputes among offshore companies. And although the holding companies are offshore, they have extensive operations here in California. And that's a symbolic economic activity that is tied to California. And there's absolutely no reason why there shouldn't be more dispute resolution in China. And I think in California, rather, particularly, it presents I think, a very attractive neutral seat when there are disputes involving Asian companies and Latin American companies. And I think.
Well, Peter, I want to thank you for taking the time to be with us today. This is, as I said at the outset, an interview that it was going to be most interesting, a most interesting background. And you, in some ways, I think, typify kind of the cosmopolitan worldview that is characteristic of California. We think outside the boundaries of this state, and you're a very good example of what California has to offer for not only the future, but for today. And I'm just really grateful that you would take the time to share some of your personal life, your life story, and your trajectory to where you are today. Thanks so much on behalf of the California arbitration and the California arbitration community. We are in your debt.
Well, Chuck, I am in your debt and the debt of CalArb more generally. I really appreciate your taking the time and investing your energy in this Conversations program. It's incredibly important to building community here in California. Our challenge, especially in Southern California, it is difficult to physically get people together, which makes these sorts of initiatives that much more important. And I really appreciate all of your effort and service in this area.
You're most welcome for everything that you have done, and we're delighted to have you with us today.
And I also would be remiss if I didn't recognize David Pollock's support.